Okay, so today what I'm going to do is I'm going to speak to you briefly about the exam which took place last week. I'm going to talk to you about extra credit opportunity, and then we're going to get into what's on the syllabus for today. So the grades from the second exam ranged widely, varied widely. I think the lowest score was somewhere in the 30s, and the highest was a perfect score of 106. And so there was all scores in between. So that's good, for the people that did well, great job. Keep it up. And a couple of you had contacted me regarding extra credit opportunity. So I wasn't planning on giving extra credit because the exams are open book, and I already give extra credit in the exams built in. But for those of you who want to do it, I thought about it, and I think this is how it's best going to be done. So if you are interested in doing extra credit, I'm going to allow you a maximum of 30 points that are going to be broken down by 10 points each. And what you can do is select the case from the syllabus that we've discussed. And what you're going to do is you're going to give me a recap of the case, but you have to spend 5 minutes per case. And that 5 minutes should go into detail of who are the players, what is the applicable law, what was the plaintiff side, or the person bringing the lawsuit, what was the respondent side. If it's a criminal case, you want to talk about the burden that was there. You want to talk about the ultimate outcome and whether or not you agree with it. So you need to be able to give me material. You're going to videotape yourself. I don't want anything in writing. You're going to videotape yourself talking about this particular case. And for every case you do, maximum of 3 if you are taking all 3 exams. If you missed an exam, then you are allowed a maximum of 2 extra credit opportunities. So if you do these and you do it well, for every one that you do, I will give you up to 10 points. If you do an awful job, I'm going to give you no points. So don't think that you're going to be reading off of a website. And I know all the websites that exist. So if I see that whatever you're saying to me is from a website that already exists that talks about the case, you're going to get no credit. So this is something supposed to be your analysis, your take on it in your own words. And if you are interested in doing the extra credit assignment, you must email me by, I'll give you the weekend, you'll have until December 7th, okay, which is a Monday. So you're going to have until December 7th. So if you're interested in doing extra credit, you're allowed up to 3 cases if you've taken or plan to take all 3 exams, right? So if you missed an exam for whatever reason, then you can only do 2. So it's 10 points per exam, essentially. And it has to be a video in your own words about a case of your choosing. And you're going to tell me all the details of the case, who the players are, what the topic is, what the outcome was. And then you're going to videotape yourself. So you can do this with your phone. And then you're going to email it to me. Do not wait until, December 7th and then try to send it, because if I don't get it by December 7th, I'm not accepting it after that. So midnight, December 7th is your deadline. If you send me a blank email, too bad. You're all adults above the age of 18, so you should be able to do it. If it's a large document and you want to use, Google Drive, that's fine. If you want to upload it to YouTube and then send it to me as a link, fine. You have to make sure that I'm able to view it. I have 90 students. I cannot go back and forth and telling you that, I don't see it. This is a courtesy. It's obviously more work for me, but I'm trying to help you out so you guys can boost your grade. So that's the extra credit opportunity. Then the final thing is everything from today on is going to be on your final exam. So when I tell you again, if you've been watching the videos and if you've been paying attention to the lectures, I test you on stuff, the stuff that I talk about, right? There's really nothing on your exam that I don't discuss at length. So just make sure you follow. And when I tell you this is a listening, just listen. But if it's something, write it down, and I'm stressing it, it's something that I need. It's going to seem like a lot of material if you actually look at the syllabus and the chapters, because we're going to start at chapter 19 today, and we go to, I think, 36. So it's from chapter 19 to chapter 36. But for chapter 19, for instance, I never test on anything on chapter 19 because I actually it's my least favorite chapter out of the entire semester. So we're going to go over it. Today, we're only going over 2 chapters. So some of the stuff, if I don't feel it's relevant in real life, I don't spend that much time on it, but I will spend more time on things that I feel will help you in real life. Again, the final exam is not cumulative. It's just going to be the material from chapter 19 until the end of the semester. And if you have any questions along the way, some of you email me when you don't understand a topic and I respond back all the time. So if there's something that you don't understand after you've attended the lecture and read it in your book, then feel free to contact me and I'll try to explain it a different way. The whole goal of this class is to teach you something so you guys can learn and know something that may be useful in real life. According to our syllabus, the final exam is going to be on December 16th. So that's when your final exam is. December 9th is going to be just kind of like questions and review. And it's really just from this point on, I'd like to say that, pretend that we started out and, we were learning, and a lot of it was intense, right? Like that first third of the semester, there was so many topics that you kind of had to know. And then the second third of the semester, which is the stuff that we just covered, was now all about contracts, details. Now, I think you'll be able to take it a little bit easier because the material is going to now be a little bit repetitive. You will have concepts that will come back to you because we've discussed it in other areas of the law. And now, again, you're all experts in business law, right? So you all know the differences between contracts, how to tell if a contract is good or not. We're going to apply those things to sales, to leases, to material items, to business formation. So for those of you who are interested, on forming your own business, then certainly pay attention as we get towards the end of the semester, because we're going to talk about all the different variations of businesses, right? The difference between a sole proprietorship and a C Corp, right? So we'll talk all about that. Does anybody have any questions before I get into the material for tonight? Anyone? Okay, I'm gonna just look. Some of you guys sent me some stuff. Okay. All right, as I said, for the extra credit, you're going to pick any cases that you want. Any cases from the syllabus that pique your interest, you're going to use them. Up to 3 cases, okay? Okay, great. So let me just, I got an email from work while I was talking and it kind of piqued my interest. Okay. All right, so, oh, there's more things, more chatty things. 3 individual videos, or can you do 3 in 1? Doesn't matter, whatever you want. But if you're going to do 3 videos in 1, it has to be 15 minutes long. And I don't want you to speak really slowly to help pass the time. I need you to speak in a way that is colloquial, right? You're spending 5 minutes on each case. So it's really not that much. If you're talking about, the case of Skeba versus Cash, for instance, you're talking about who the players are, you're talking about the fact pattern, you're talking about the holding, you're talking about the outcome, and then you're talking about what you feel is right. Was that the right outcome or not? What's the legal principle that came out of that case, right? You can do that in 5 minutes. For those of you who volunteered on a regular basis to talk about cases, then you know that sometimes when you're just speaking about it, it takes a couple of minutes, so it's not too bad. All right, I'm going to now start the lecture on chapter 19. Okay, so chapter 19, as I mentioned a little while ago, is my least favorite of the entire semester. So this is this is all listening, okay? If I tell you to write something down, go ahead. So chapter 19 focuses on, it's about sales and leases. And the reason I don't really harp on this stuff too much is because we deal with this stuff every day, right? You know the difference of purchasing something versus leasing something. So that's common sense, right? So what is the difference between buying something and leasing something?
When you lease, you are not the owner of that. If
Exactly.
you are owner.
Exactly. That's exactly it. So when you're leasing something, you're not the actual owner. You are just borrowing it or using it for a finite period of time. However, when we are talking about purchasing an item, it is yours. You are the actual owner. So chapter 19 focuses on, which areas of the law are applicable when we're talking about the sale of goods. So when we talk about the sale of goods, the section of the law that's applicable is Article 2 of the UCC, the Universal Commercial Code, Uniform Commercial Code. And Section 2A talks about leases. So whenever you're leasing a product or an item and something goes wrong, so the attorneys or the judge or the court will refer to it's an applicable statute, Section 2A of the UCC. And if it's about an item that was being purchased and then there's a disagreement about that, it's Section 2 of the UCC. When we talk about the sale of goods, what are we talking about? We're talking about an item that is now possession is being passed, right? From one section, one person, one owner to the other. Sometimes, and I mentioned this before, when an item is in question, but there's also now the aspect of service that goes along with it, then sometimes Article 2 is not the proper a vehicle to be the law that's applicable. So it wouldn't be the only area. You would have to look at outside case law as well, not just that area of the law, to determine what is the cause of the breach of the contract. And one of the examples I think I had given you before is, let's say you're hiring somebody to do tile work in your bathroom or in your kitchen, right? And the tiles are supposed to look a certain way. While after they were installed, they looked off, right? Maybe the lines or the designs didn't meet. So is that a problem with the tile itself, or is it a problem with the person who did the installation? You cannot just apply Article 2, which deals with products and the sale of goods, because maybe it wasn't just the sale of goods, maybe it was just the way it was installed. And so if you have a scenario like that, the court looks at what's the predominant factor. What is the factor that was, the biggest, the bigger one of the two? Is it the way that it was installed? Had they been installed by somebody else or in a different way, would they have looked right? Or regardless of how they were installed, there was something defective about the tile itself. So that is just kind of to give you some context about it. When we also talk about Article 2 and Article 2A, there is these concepts that pop up about good faith. And good faith is one of those things that's hard to quantify or hard to really pinpoint, but we kind of all in the legal world kind of know it when we see it. And really the simplest way I can explain that is when you're dealing with somebody and not like trying to screw them, essentially. You're dealing with somebody in an honest way where you don't have any deceptive means or trying to, mess up a deal. Good faith is acting in a way to try to make the deal happen, right? You're not being sneaky, you're not being deceptive, you're not being shisty. No, you're trying to make this thing go through, but and so you're acting in good faith. And good faith really comes into play not so much even when it's persons like individual people, but more so when it's merchants dealing with each other, businesses dealing with each other. When a business is dealing with another business, they really need to be acting in good faith. Why? Because they are entering and exiting contracts on a regular basis. And so it's kind of that level of honorability, and doing the right thing when need be, because that's how businesses go through. If you develop a reputation for being sleazy or not living up to your word or not living up, to your contracts, people in that industry are not going to want to work with you. But if you've developed a good reputation of meeting your deadlines and doing things the right way and not upcharging when you didn't have to for material or whatnot, then you develop that good reputation. And so people want to deal with you more and enter into business, and businesses make the world go round. Unconscionability is another term that comes out of the principle of Article 2 and 2A. And unconscionability is, generally speaking, courts allow two parties to enter into whatever type of contract they want to, right? As long as it has those four things we talked about before. They're not going to really get into the nitty gritty, because as long as two parties agree to the contents of the contract and they were both of sound mind when they did it, and it was legal in nature, and there's nobody under a disability or anything like that, then courts don't get involved. Why? Because when two businesses or two people are entering into a contract with one another, there's freedom of contract. You can contract over anything. The term unconscionability comes into play when the terms of a contract are so egregious, so awful, that it would be unfair to enforce that contract. And when do we see that come into play? Well, it's really when it's a big business conglomerate, maybe getting into a contract with a single person with, a low-level education who maybe doesn't speak the language, right? So the example I like to give is, let's say you own a small little those like stands that they have in like buildings, where you can get, what the hell is it called, where you can go get like soda and coffee, like some snacks. Like if you enter into any commercial business, they have that. Convenience store, that's what it is. And so it's a big building, right? 100 floors, 50 floors, whatever it is. And so let's say the owner of that building wants to renew your contract with you, and tells you, hey, listen, here's our contract for the next, 5 years together. I need you to sign this so you can continue to stay here. And you're like, okay, do I need to get a lawyer? No, you don't need to get a lawyer. This is what it is. And you kind of just sign off and not really pay attention. But meanwhile, the terms of the agreement have tremendously increased your monthly rental obligation. Stated that you have to now give a portion of your profits to the owner of the lease. The terms, you signed it, right? Maybe you did in fact even read it, but you didn't understand anything and you didn't go to an attorney. Well, maybe a court will say that's unconscionable because nobody in the right mind would have signed a contract like that. It's different than if you signed a contract knowing all the different terms, but then you cannot fulfill it. I really think about, applicability when we talk about contracts. Look at, if you're from Staten Island, you know about the Empire Outlets, right? And all the stores that had signed on leases probably, right? And so they were supposed to open. Then you have Corona hitting. Are they able to get out of those lease agreements? Is it better for them to pay those penalties and get out? Is it a breach of contract? Should they be let out of those leases? So at those points in time, you have these agreements between two business entities that had agreed to something. They acted in good faith. There was nothing unconscionable. Can they breach their contract because of this whole worldwide pandemic? I don't know, just kind of throwing it out there. Okay. I'm not going to get into the textbook touches upon procedural unconscionability and substantive, but this is a 100 level class, so I'm going to skip that part. You don't really need to know. The next thing, as I said, when we talk about merchants, which are the people that are dealing in businesses, they are held to a higher level of needing to meet certain credentials and criteria. Why? Because they're dealing with businesses all the time. And so they are held to that higher standard. Like they should know better than doing something that they shouldn't be doing. Just also look at my notes here. Okay. Remember when I talked about whenever you're entering into a contract, you should have as much stuff in there as possible. You should have as much detail in there as possible, because it's better than having, open terms or whatnot. Well, Article 2 and 2A actually allow contracts to have an open term, open pricing, when it's two merchants dealing with one another. And the reason for that is it's typically businesses that deal with one another on a regular basis. It could be something based on market value. And so just by having an open term in that respect, it does not invalidate a contract. So when you're dealing with contracts between two merchants, under the Article 2 and 2A, which is really an update of older law, they say that you can have certain open terms and it would still make the contract valid. Okay. Auction. What is an auction? You all know what an auction is because you have, I'm sure, used eBay or whatnot. Anybody want to tell me what an auction is? Anybody? Yes, when you bid on items. But it's more so, it's not just when you bid on item, it's when you bid on an item and whoever is the highest bidder can get it, right? And an auction is, there could be a reserve, there could not be a reserve, right? And it's just really trying to get the highest price for a particular item. I learned the hard way about reserve bids. And if you're trying to sell an item for a certain price, I was putting up this item for my mom. This was years ago. It was a silver something made in the 1950s, I think, or 1940s. I don't even remember. And I thought it was an antique thing. We were going to get lots of money. I started the bid off at $1. Okay. And I'm thinking this thing is going to go into the thousands of dollars. It sold for $10. The auction ended and the highest bidder was $10. So the guy's like, ship it to me. And I was like, no, that's too low of a price. He's like, yeah, but we entered into this was a long time ago. I think maybe in college at the time. And I was like, but this was my first auction. I don't want to sell it to you for that price. That's such a low price. I thought I was going to get a lot of money out of it. And he was like, well, you're bound by, whenever you put something for sale and somebody buys it, that's it. And it was a contractual agreement. So I ended up selling it for $10. I told my mom I sold it for $200 and gave her the difference, because I wanted her to feel, good. But I learned the hard way about reserve prices. If you can excuse me for a minute, I just have to yell at my children because they're being very loud. Okay, so those are auctions. That's what a reserve price is. Let me see if there's anything here. Yeah. I yelled at my kids, by the way, the other day, and I was in a conference call, but I forgot to mute it. Not good. Not good. I try to now remember to mute it. Just embarrassing. That's what happens when you work from home. Okay. Electronic signatures, e-signing. We are dealing with e-signing a lot more now than when this book was ever written, right? E-signatures are as good and as effective as regular signatures, right? As a matter of fact, due to COVID, you can even now get documents notarized virtually. You don't even have to be with the notary at the same time to get your signatures notarized. The textbook also talks about the statute of frauds, which we discussed also. Items, and this is going to sound very familiar to you, I hope. When we talk about the sale of goods that are worth more than $500, that must be in writing in order for it to be an enforceable contract. And the other thing, again, parole evidence, which is also mentioned here, which we talked about before. And the parole evidence rule is what? It's the final expression of a contract. So after parties have negotiated the terms, it is the final expression of a contract. Now it's put in writing, and it's only whatever's in the four corners of the document. You cannot use or reference any other conversation that you had to get to where the point you're at now. And that actually concludes everything I want you to know or learn about for chapter 19. Any questions before I move on to our second and final chapter, chapter 20 for the night? Going once, twice? Okay. So chapter, let me go back to my syllabus here. Okay, so chapter 20. Chapter 20 talks about performance. And when we talk about performance, we're talking about the performance of the two parties in the contract. Now, the basic obligation of a seller of goods is to transfer and deliver the goods. Okay, this is a write it down moment. The basic obligation of the seller of goods is to transfer and deliver those goods. The obligation of the buyer is to what?
Pay for them.
Pay for them, exactly. So now this was from your textbook, right? I want you to just think about Amazon or anything that you order from. If you are ordering from the seller, what's their obligation? They got to get you the stuff. And you, as the purchaser, you have to pay for that stuff, okay? So a little common sense, but makes sense. Now, each side in this contractual obligation should not impair the other party's attempt to carry out their obligation, right? So if I am waiting for a package from Amazon and I say that it has to be, I have to sign for it, right? I cannot impede them trying to deliver it to me by, constantly not being at home or evading service or whatnot. That's me hindering their duty to, bring me their stuff, transfer their stuff. And I cannot also withhold money, right? In order for both sides to actually perform what it is we're supposed to perform, our obligation, one side transfer delivers, the other side pays. When we talk about now the performance of the seller, right? The seller of the goods, there is tender, like there's a thing that has to be, it's called tender of delivery time and time of tender. I'm sorry, time of tender and place of tender. And that's really when that transfer is happening. A place of tender and time of tender is just when this item is going to be transferred, place and time. So if a seller is going to be shipping their items to me and I have to sign for it, is it reasonable that they ensure that I get the stuff at 2 a.m. that I need to sign for it? No, it's not reasonable, right? If I'm supposed to be picking up something from the seller, let's say it's a local shop, and they tell me to come and meet them in the back alley of, I don't know, where is there, in a dark street on Staten Island that doesn't have any light bulbs or something, so I can pick up my, postcards that I just got printed. Is that a reasonable place of tender? No, I'll save you that, right? No. Now, what if and I don't want to say, like, if I was engaging in illegal activity, then perhaps, but we're always talking about legal activity, okay? What if, however, I am running a club where people come and dance and hang out, and the club opens at 11 p.m. and I need alcohol, right? And I have an alcohol supplier coming in. Perhaps then it would be reasonable to ask for my delivery to be made at midnight or 10 p.m., right? Outside business hours, because of the nature of the business. So you always have to look at the nature of the business. But if I'm picking up my postcards, encouraging people to vote, then that should be done at a reasonable place and time. So reasonable place and time, generally speaking, is 9 to 5, Monday to Friday, at the place of business, or if it's being shipped, the residential address. So that's all that means. Place of tender, time of tender is where the item is actually being transferred to. Any questions? Common sense stuff, right? Okay. If the contract doesn't specify where the item is, it's usually just going to be the seller's business or or a home address, just as an FYI. Now, this is something you need to know, so pay attention. And I'm going to talk to you about the perfect tender rule. The perfect tender rule. And the perfect tender rule is it imposes on the seller to conform the items exactly to the terms of the contract. And if there's any failure, then the buyer has 3 options. And I'm going to now just break it down to you just in, again, plain English. Let's say I ordered from Amazon 100 red balls, bouncy balls. 100 red bouncy balls. Let's say I received 90 red ones and 10 orange ones. What are my options?
You can return the 10 and the red ones.
Okay, so I could return a portion and keep a portion. Okay, what else? Somebody wrote refund. So you want a refund from the entire thing? I'm going to assume yes. You want a refund for the entire thing. And what's your third option? So you can keep it. Exactly. So that's what the perfect tender rule is. The perfect tender rule says that when you order something, you have to get it exactly as it is, as you ordered it. But if you don't, you as the buyer have 3 options. Keep the whole thing, reject the whole thing, or keep some and return some. Okay? That's the perfect tender rule. I like to sometimes like give this example. Like I remember, Ben, back in college, we went out, a couple of my classmates and I, we went out to lunch or dinner or something, and one kid ordered his dinner and he like ate the entire thing. Then when the waiter came to ask how it was, he was complaining about it. Like he said it didn't taste good, he didn't like it, blah, blah, blah. But you ate the whole thing, right? So what are the options at that point? You ate the whole thing. So it's, if you had eaten a portion and then you wanted to return it, get a refund, you know, decide to eat it, but you ate the whole thing. What are we doing here? If you ordered something that was an edible item, right? Sponge cakes. I love sponge cakes. If you ordered 100 sponge cakes, you're not going to be able to do any of all 3 items if you ate 99 of them and then you want to complain to the company that there's something wrong, right? So we always have to use common sense here. So you know, you have a couple of erroneous things or things that don't match, you can you know, try to enforce the perfect tender rule. But if you ate the whole thing, if you eat the entire dinner, then don't try to, you know, get a refund on it because you ate the whole thing. Okay, that's one of my favorite things of this chapter. Okay, the parties can agree between themselves to remedy the problem. Perhaps if you order something and you got the wrong item, you'll get a partial refund and you'll get to keep the item anyway. Sometimes that happens. As long as both parties agree and have a mutual understanding of how to remedy the situation, then that's also always an option. You always have to give, not always, but generally speaking, you have to give the seller an opportunity to cure the error within a reasonable, you know, period of time. If it's not reasonable, then, you know, they're not going to be able to cure the problem. Again, essentially, think back to a contract, and the purpose of a contract, it's an agreement between 2 parties who want to enter into, you know, a relationship with one another. So if something doesn't work out for whatever reason, you want to give that person an opportunity to actually fix it. Talking about performance of the buyer, that they have to pay. Sometimes when you're also, when the seller does something wrong or they don't give you what they were supposed to do, you can give them a time frame. If I don't get this item by this date and time, then, you know, I just want a full refund because it's no good to me. If you send me, you know, all these balls after, you know, next month, well, my kid's party is going to be finished, so it's not going to do me any good. It's not going to work out. I need them by this date. Otherwise, don't bother sending it. That's that sort of thing. Also, inspection. When you get an item, right, you have a duty to inspect it. When do we see that into play, right? You have, when you buy something, what is usually set on the return policy of these items. You have a certain period of time to return it, right? You have 30 days to return an item, sometimes 15 days, sometimes 60 days, depending on what's going on. So it's on you to inspect the item within a reasonable time frame, and then if it's not good, notify the seller and then return the item. So that's going to be an obligation on the purchaser. You can reject it. You have to, inspect it. Once you accept it, you can't change your mind, right? Once you've taken it in, it's all good. You ate the sponge cakes. You can't return it. You can't try to return it after you ate it. Can you revoke an acceptance? Sometimes you can. It depends on the item. Let's say you ordered boots and you specifically purchased these boots that were being advertised as rain boots so they can withhold rain. So, it was very sunny and so you weren't able to test them out. But on the 31st day, it was raining. You wore those boots, and now you notice that they're letting water in. So the purpose that you bought it for, you were not able to actually test it out because of the circumstances. Well, in that case, you initially accepted it, but you would be able to return that item based on, their the way that they presented it to you and that falsification of that. All right, let me see here. Talked about that. Let me just see here. Perfect tender, cure. Okay. I'm going to give you the phrase of the day. I actually wrote this down today. Okay. So for attendance, and I think this might be, I don't know if it's the 6th or 7th month you have. Don't forget, once you have all 10, or once you have 10 of them, you can email them to me in one document. That's going to be how you get your attendance. Thank you, 8th. That's going to be how you get your 100 for your attendance, which is 10% of your grade. So for tonight, the secret phrase is, the sun will come out and make everything better. Okay. The sun will come out and make everything better. The sun will come out and make everything better. I'm going to have to excuse myself for a moment. It was a child thing, of course. Okay, so that is the secret phrase. We only have a couple other things, and then we'll be done for the evening. Let me just look at my syllabus. Okay. You can always have something called a non-happening of a presupposed event. And a non-happening of a presupposed event is when the seller is excused from the duty of performance because the contract took into consideration something happening and it didn't happen. So it's like when you're both counting, or you're both sides have this understanding that certain conditions will be there, and then a condition doesn't happen, and so one of the parties will be absolved from actually going through with the contract. It's not something, it's just a listening. That's not really something not a big deal for you guys. Anticipatory repudiation. That one is something I want you to know. What is anticipatory repudiation? That's when you're actually allowed to break the contract because you know the other side is going to break their end of the contract. So you can breach your end. You don't have to perform your side of things because you know the other side is already breaching their contract. So you can kind of breach it as well. You don't have to keep doing what you're supposed to be doing because the other side is already in breach. That's fun. It's a fun thing. What else here? And I think really, the only case that we have for tonight is Hessler versus Chrysler, Lake Plymouth. I don't usually test on that. I might, because I don't know. I might. Who read that case and can tell us a little bit about it? It's kind of interesting. Anyone?
I've read it earlier. I don't know how accurate I'll be able to represent the whole story, but I
That's
can
okay.
try.
Sure.
So, a gentleman who is basically the defendant in this case, or purchased a car, pre-purchased a car,
Mm-hmm.
Plymouth. I don't know which model it was. That's happening in the end of 90s.
Yeah, Plymouth, I
So
think.
he paid $5,000 deposit, and he purchased that purple color. I guess, I don't know, limited edition or whatever, very rare. It doesn't matter.
Mm-hmm.
The price of the vehicle was $39,000. He paid $5,000 deposit to the dealership, and he was expecting to get his car whenever they start basically putting it on, I don't know, in the factory or whatever, out of the factory. So he made a deal with another gentleman, and he sold basically his car that he purchased from the dealership for $50,000 for a third person. And they got to contract, of course. And the third person part of that whole case paid $10,000 deposit to the original, I don't know how to say that, original purchaser of that item or car in this case. But in the meantime, the owner of the dealership contacted the Mr. Hessler, or what's his name, the first purchaser of the vehicle, again, just to put that on the line so it don't get lost. And they told him that there won't be any models of this vehicle delivered to the Midwest. I don't know where exactly that thing happened. So,
That's okay.
But Mr. Hessler attended some meeting of I don't know, Chrysler or General
Right.
Motors. I don't know exactly who used to build those cars. They're out of market anyway. So and he saw that basically his name is on the list, and there is a car built for him. And after that, he went to some other event. Oh, he went to the dealership after a few days or months. I don't know exactly when that happened, but he basically saw his car there. Same color, whatever he ordered, same stuff. But the owner of the dealership didn't want to give him the car because he said he went behind his back and he resold the car for more money, and that price on the same car that he purchased on his car was already 70 something $1,000 in the dealership. Because of the color, who knows? Because of what? It doesn't matter. I think it was like number one built out of 100 or something like that. There was some rare or number or whatever. And so he paid those 70 something $1,000. He bought his car instead of buying it for $39,000 because he entered a contract with a third person. So to be able to resell the car and get those $50,000 and basically do not breach the contract, he paid the 76 or 70,000, the price that the dealership asked for it. So the first time he signed for 39, but he paid 78 for it. So that's another story anyway. So he resold the car to a third person, and in the end of the story, he took him to court and basically got almost $30,000 back because of breach of contract, right? So the dealership, right, they signed a contract for $39,000. After that, he went back, he sold his car there, and the owner told him that I don't want to sell your car because you go behind my back, you do any deals, and I'm gonna sell the car for $80,000 instead of 39.
Right. It was essentially a breach of contract, right? They had entered into a contract, at the beginning. There was a deposit that was made. Then there was anticipatory repudiation. The guy went behind their back. He did that. And he the gentleman was able to recover that in court. This is a case I don't want you to worry about. It has a couple of complicated factors in it. There's buying and selling, getting out of contract, and there was, I'm not sure if you hit all the pertinent points, but I don't want to kind of confuse things. But it's just, again, about a, you know, the essence here.
It all stemmed on the term as soon as possible too,
Yep.
right? Like,
Yep.
didn't it ASAP? Like,
yeah, because he was
four
first.
letters.
He wanted to be first on that list. Like, he wanted to get this car. It was like a limited edition car. He put that deposit down. He wanted to be like one of the first people to have that. And then because the dealer was able to actually get a better deal, you know, a better deposit somewhere else, he gave that car that should have gone to this one guy and gave it to somebody else. And that was also one of the problems that we had here. So, you know, you enter into a deal, you're supposed to be acting in good faith. You're supposed to be honoring those deals, not trying to make money off of a deal that you already entered into by doing something shady, right? So you want to act always in good faith. So that was that. Let me just see here. That's the last thing I have for tonight. Does anybody have any questions about any of the concepts that we discussed today? Today was pretty much common sense. Any questions about your exam, the extra credit stuff that we went over? Going once.
I just missed that beginning part for the extra credit. Sorry about it. I just turned on my
Sure. The
audio.
extra credit is if you're interested in doing extra credit, you have until December 7th. You can select any 3 cases for that we discuss, and you're going to be doing a presentation on them. You're going to videotape yourself and you're going to email me that presentation. So if you've taken, you know, the 2 exams already, you're going to take the 3rd one. It is up to 10 points for each case, a minimum of 5 minutes. It should be about 5 minutes for each case. I will give you up to 10 points depending on how well you do. You should talk about the fact pattern. You should talk about the legal concept. You should talk about the, you know, the conclusion and whether or not you agree with it. And I have to get the videos by December 7th at midnight. That's the deadline. December 7th at midnight is the deadline.
Okay, sounds good. And we don't have to wear a suit for the presentation, right? No, I'm joking. That was a joke.
Oh.
No. Thank you.
No problem. All right. Any other questions? Okay. When we are done today, I'm going to post this up on class. If you have any questions, then you guys can just refer to the video from tonight. All right. Have a great night, everyone.
Have a good night, Professor.
Good night.
Good night.
Good night.